My most watched videos have to do with executor mistakes or executor misconduct. If you are named in a will as an executor or you plan to petition the probate court to be the personal representative of an estate, you need to know what is considered executor misconduct. Hello again, this is Certified Probate Real Estate Specialist Daryl Williams with Win-Win Realtors here in Southern California. If you are new here and you like our content, be sure to like, share, and subscribe. Let's get started. Beneficiaries and heirs often get frustrated when they perceive that the probate administration process is taking too long to settle, or when they believe that the probate administration process is being mismanaged. It is important to remember that the executor or the administrator of an estate has a fiduciary relationship with the beneficiaries and heirs, which means that the administrator or executor must make all decisions in the best interest of those beneficiaries or heirs. The following are examples of executor misconduct. Withholding inheritances is considered executor misconduct. An executor cannot change the will or purposefully withhold an inheritance from a beneficiary or an heir. Misappropriation of funds is considered executor misconduct. Misappropriation of funds happens when an executor uses the funds for their own personal reason or outright steals the estate funds. Lying about estate assets is considered executor misconduct. An executor not communicating with the beneficiaries is considered executor misconduct. The law requires executors to keep beneficiaries reasonably informed on the proceedings of the probate administration. Mismanaging estate assets is considered executor misconduct. When an executor participates in self-serving dealing or commingling estate assets, that is executor misconduct. Here are other examples of executor misconduct. Underpaying beneficiaries, charging excessive fees, disloyalty to trust beneficiaries, failure to follow court orders, failure to perform required duties, dragging the administration process along, committing fraud, falsifying liabilities, negligence and incompetence. All of these are considered executor misconduct, and this list is not all-inclusive. Question of the day: have you ever been involved in a probate administration where you believe the executor committed executor misconduct? If so, let us know what you did about it in the comments below. These issues must be dealt with prior to the executor distributing proceeds to the beneficiaries. The bottom line is, if an executor breaches their fiduciary duty, they can be held liable. However, of course, in order to hold them liable, an enforcement action against them has to be taken, and that usually means time and money. If you've gotten value from this video, be sure to like, share, and subscribe. I'm Daryl Williams. If you have any questions for me, my contact information is in the description. This video has been for information purposes only. It is not legal advice. I am not an attorney. If you need an attorney, please contact one. If you need a probate attorney here in the Southern California area, feel free to contact me for a referral.